Chandra? Okay. All right, so good morning, everyone. Today is Friday, October 23rd, 2020. This is a special meeting with our Public Defense Commission.
Commissioner, I don't know if you can hear me, but you're muted, so we can't hear you right now.
So, Anne, are you able to unmute us?
Okay.
Well,
yeah, but we can.
Are we doing the audio through mine?
Yes, I think so. Okay, go ahead.
Can everyone hear me now? Can you hear me now?
We can hear you now. Thank you very much.
Okay, thanks. Okay, once again, today is Friday, October 23rd, 2020. The time is 9:02 a.m. This is a special meeting with our Public Defense Commission, and attending from the Board of County Commissioners in person are Commissioners Duncan and Filios. Joining us via Zoom is Commissioner Bill Brooks. Do we have any changes to the agenda? Hearing none. Our one and only and primary discussion item is the proposed Public Defense Commission rules. And at this point, I think I'll turn it over to the chairman of the Public Defense Commission? Should I turn it over to Kathleen?
That's the director.
Or the director, excuse me. Kathleen, are you there?
Thank you. It's good to see you all,
Okay.
Commissioners, Chair. Thank you for having this meeting with us. We wanted to make ourselves available to answer any questions you have about the rules that are now proposed, and to answer any questions, to get any feedback from you, and any other concerns that you might have. We want to be available to you. And Chair, I was having difficulty, I don't know if anyone else was, but I was having difficulty hearing you.
Okay. Is this any better now? Can you hear me?
A little better, but it's still very hard to hear you.
And James just left.
Are you going to, can you grab James,
Did you?
please? Okay, let's see if we can handle this before we get any further. I'm
If we
sorry?
do what? But that's the problem that we just had with all the feedback. So it won't allow us to do it. So I think that the microphone is on Anne's laptop. Yeah. Oh. There's a microphone on the camera?
I think that's what James was saying.
Okay. Okay. So I'll do that.
Okay, Kathleen, is this any better? Can you hear me now?
A little bit.
What if you just turn it, Ann? Or this is probably useless at this point. Is this any better, Kathleen?
Yeah, I think we'll be able to hear you okay. Thank you so much, Chair.
All right, I'll try to speak up. So anyway, just to back up a little bit, the reason for the meeting, I guess, is we had some concerns regarding the proposed Public Defense Commission rules. And so Director Kathleen Elliott's been opening the meeting for us, so go right ahead.
Thank you. We just want to give you a little background, what brought us to what is before you as the pending rules and going into the proposed rules. We started this process on two principles last year. They're the final principles that we have to negotiate on a 5-year plan. And that's independence from political and judicial influence and resource equity. We had started that negotiated rulemaking last year, and at the request of counties, we continued it into this year. Last year, we met with all the counties in 7 meetings and asked for comments, for ideas. And this year we had in July one large statewide Zoom meeting to negotiate the rules. Prior to that, we had sent out an outline, and we thought that that might be the best approach, because prior, when rules were written, and this was before I got here, the rules would be completely written and feedback would be asked for. Folks felt like they weren't getting their input in. And then last year we went out and just asked for ideas and concepts And the feedback we got was we want something more substantive, and so we did the outline this year. Immediately after the negotiated rulemaking, we began to incorporate what we had heard, writing out the rules, fleshing them out. We had the public hearing on those. A month before that, we sent out the draft that we were working on so that people could start to get familiar with where the direction of things. And then we're on the state publication deadlines, and a week before the public hearing, the actual pending rules were published. And then we had the public hearing last week. So that's where we are. We're getting ready to go to the commission, the Public Defense Commission, next week, at which point they will make their decisions on the proposed rules, and then those will be published and we will go to the legislature. The Public Defense Commission is absolutely supportive of the negotiated rule process. It's not a process you have to do in the state of Idaho, but they have always been committed to that, and we think there is huge value in that. We are continuing to work with folks as we hear comments. We want to get this fleshed out and to continue to move forward on this. A couple of other things. The governor issued, I believe it was his first executive order when he took office. He issued an order that he wanted red tape cut. He wanted rules simplified. We heard from our stakeholders that our rules were not clear, there were some contradictions, they didn't understand them, often couldn't find parts of them because we had documents incorporated by reference that actually didn't appear in the rules, even though they had the effect of law. And so we have taken that seriously, and our restricted words, the shall, have been reduced by about 85%. The language, the words have been reduced by between 65 and 70%. We have no more incorporated documents. We are trying to make it easy for our stakeholders, easier. And instead of listing things as they were, we have broken it down so that it's broken down by responsibilities, because we heard, especially from county commissioners and clerks, we cannot find what responsibilities we have. And so our definitions are in the first chapter. The second chapter is the responsibilities, and it's broken down by who has those responsibilities. Our third is the review, our review process, appeals process. And the fourth are the financial assistance and the training. So that's kind of the background on that. We've tried to be very true to comments that we've heard, and we've tried to be very true to prior negotiated rulemaking. An example of that is when workload was passed, the counties asked that if they needed additional attorneys, that if the state didn't pay for those, that they weren't deficient if they didn't have those additional attorneys. So in other words, the state has to pay for the workload, and we have made sure that things that were negotiated like that continued on. We've been asked about redlining, and because of the reduction and because of how things were set up initially, it would just be a mess and almost impossible to do a red line. Even those of us who've been working on this for months and months wouldn't be able to read it. So what we're doing is we want to be available to you to ask questions, and then we're tracking. Our goal is to track through these important comments and make sure that we're not missing anything. Mainly, I wanted to be open to answer any questions. Chair Bowles and Vice Chair Frederickson are here. Tammy Sopin and Jennifer Rourke, who work in our office, both our attorneys, are here, and we are happy to answer any questions that you have, take your comments, and just have hopefully a collaborative process.
So Kathleen, I do have a question. You said that the commission was going to vote on them next week, but yet the public comment, I think the deadline is October 28th. Yes,
Commissioner, this is Commissioner Duncan, right?
Yes.
Okay. Excuse me, I'm sorry, you're just not on my screen. Yes, Commissioner, so the comments closed October 28th, and we've been working on them solidly And then the commission meeting is October 30th.
Okay, so essentially the commission has 2 days to take all of the comments and make the appropriate changes before they vote on them on the 30th?
So as a staff, we are working on those comments, and we have been, and will continue to, and are keeping the commission, the chair and vice chair are familiar with what is going on, and we have a process that the leadership has approved. And so it's not like we're waiting until the last day to work on this. We're working on this, we're integrated, we've been having meetings, we're taking comments. We've been working on this solidly, so it's not like we're waiting until Wednesday at 2 or at 5 p.m. to start the work.
Sure, sure. No, I understand that part. It's just Kootenai County had a meeting set up for 11 o'clock Monday morning, to get the full board understanding what Kootenai County's concerns are. And so then our comments probably won't be received until Tuesday or Wednesday before the deadline. So today is going to be, we're a little bit caught short, I feel, because our meeting was scheduled for Monday at 11. So we'll do the best we can. As I said in the meeting at the public hearing, I have concerns about the financial aspects of some of the unfunded mandates, support staff, even housing of additional attorneys, investigators for additional attorneys. So there's a lot of financial, I think, implications if these rules are passed. And the other, one of the biggest concerns I have is the removal of the thing that you actually alluded to earlier, where if the Public Defense Commission doesn't fund these mandates, that the counties wouldn't be responsible for them. But that has been removed.
And I don't know if other people, I'm really having a hard time hearing. I get the gist of what you're saying, but it's very hard for us to hear.
So
We could certainly transfer to a telephone conference if that would make it easier for everyone to hear one another. That may be a better route. I know that
Might be easier.
the Board of Commissioners often has
So I don't know if it's
conference calls, and we could transfer to that modality if that would enable better communication.
well, let me find out which microphone here is supposed to be picking us up.
Okay.
Thank you.
Go ahead, Leslie.
Okay, so is this better? Can you hear now?
It's slightly better, but it's really weak. I think it's just very hard to.
How about this? Is this better?
Not really.
Let's go to the phones.
All right, well, let me check. All right, sorry.
Well, are you two?
Thanks for working with us.
Yeah, no problem.
Yeah, no
How about
problem.
this one?
That's great.
Okay,
That's-
so
That's because
it's
that's where the
only-
speaker is.
It's only our laptop
Top that's
audio
picking it up.
That's picking it up.
All right.
So
Okay.
I'm not sure how else to do this, but, all right, well, I'll just.
No, go
I'll
ahead,
stay right
go ahead.
here, and then, Chairman, if you don't mind coming down here when you have your comments.
I've got mine.
So I did give several comments that day, so I don't really want to go over all of them this morning. But I think that some of the problems is coming in between, having the Public Defense Commission rules come in between the Board of County Commissioners and their Public Defender Office. So there's a couple statutes, 19861, 1, that talks about the public defender serves at the pleasure of the board, and then the deputy public defender serves at the pleasure of the public defender. So those are very concerning to me. The definition of vertical representation is a huge departure from the current rules, and I think that there's already statute that talks about providing defense to the extent reasonably practicable. And so to have these new rules over, I don't know how else to say it, but just kind of overdo it. the other thing is having the roster be under the control and then creating a liability for the county if names are removed from the roster. And then, you know, does that mean the county has to fire these people and then incur the liability from lawsuits for arbitrary and capricious termination? So there's just a lot of concern, and I'll let Chairman Filios, if he's got anything else to add here.
Go right ahead.
Yeah, so it's
I have
just,
some of the same concerns, but go ahead.
right. The deficiency reporting. So I have a very huge concern on the fact that if the non-material deficiency is not cured according to the deadline set by the executive director, then the non-material deficiency will be deemed material. So that lends itself to unfair application when, if it's completely out of the control of the defender or the county to cure it, then does that mean the Public Defense Commission comes in and takes over when it's not in the control of the county to cure the deficiency? So there's just a lot of things in here that I think are a huge departure of the current rules, and it really concerns me that it's going to be a financial burden on the counties that Kootenai is not going to be able to make up for. Our growth is so extreme right now, and we actually have to provide a building for our attorneys, for new judges, and we're just really tight on funds. And I know for a fact the legislature is going to pass some type of restriction on taxing ability for counties. So I think that having the Public Defense Commission vote on these things next, I guess it's Friday the 30th, without changing some of these things, I think is just a huge mistake. And I would ask that it be put off and more dialogue be done if changes are not going to be made.
So let's address that last comment first. That's what I'm saying, we are working. So we are in this process. That's what the whole public hearing was last week. That's what it was, the negotiated rulemaking was last year, in July. And that's why we tried to keep stakeholders informed and sending information out. We are responding to these. We are responding to comments, and it doesn't mean absolutely everything's getting changed, but we're working on this. We want this to be a collaborative effort, and we are addressing issues that have been brought up to us and are working on that.
What is the criteria that would indicate a change? So if so many counties are against a certain rule, will that rule be changed? I mean, how is the commission going about making the changes or incorporating the concerns into a new document? And we really did not have enough time. I mean, there was one meeting over the summer, then October 7th, I think, the final draft rules were sent, then the hearing was a week later. That is not enough time to go in here and fully digest it. I've myself, with 14 department heads, 17 departments that I'm involved with, you know, I've taken an extraordinary amount of time to do this. So, you know, my concern is I don't know if other counties have had that amount of time. You know, I spent a day and a half away from my family, from work and everything, to come down to testify. So to me, this is just too much being put forth too soon, and not enough time to truly go in here and say, this is a whole rewrite. This is not just a Red Tape Reduction Act. I haven't done a side-by-side comparison, but I know that one is being done, and I'm going to be interested to see it. But this is very, very concerning to me. If, you know, the first foremost reason is that we cannot handle the financial burden if these rules pass. I guarantee you that there is no way we're going to be able to do that. Then we're going to be found materially deficient and willful if we don't. I mean, what departments am I going to cut? Who am I going to underfund so I can fund these mandates that the state is not funding. So I'm a little bit passionate about it. It's early on a Friday morning. I haven't slept a lot this week, so I'm just a little excited that this is just being done way too quickly, way too soon.
So, couple of things. We have been trying to keep everyone in. I am committed to transparency. So we sent out a month before the public hearing to all stakeholders. We sent the work that we were doing, the draft that we were on at that moment. We wanted that to be out. We didn't want to wait. We are subject to publication by the state's deadlines, and we wanted to have ample time for people to comment. We didn't want to cut that short, so a month before we sent out the draft, the working draft we were working on to all stakeholders, and then the publication came in, and we have continued working on it. I understand this is a different process, but it is the process. We are here for comments. You asked if there's some kind of threshold really for, does it take 10 votes, or what we're trying to do is look at every comment. We are looking at every comment. We're working we're taking suggestions. We're adding information. We are, we are doing what agencies are supposed to do, which is to consider the comments. We also have other mandates. We're mandated to do these rules. It was a 5-year plan. We've been working on the 2 new principles for 2 years now. And so we have different input and different sources, but every comment is considered, and we've had some very, very good meetings. We think the comments have been great, and we're able to integrate many of them.
Okay.
So a couple of things. You talked about the roster and this hiring and firing idea. Our concept is not to walk in and tell Kootenai County, this is the person you must hire. This is the person you must fire. Our mission from the legislature is that we follow, or we promulgate standards, we set standards, and we enforce those standards. Essentially, we're a compliance agency. And because we're a new agency, we have been working through this, and it's a process, and we're getting more to a compliance time now because the standards are coming into effect. Doesn't mean that I walk in and say, public defender, you have to fire this person or you must hire this person. We're working to make sure that the roster is a useful thing for courts, that the roster is useful for counties, and that we know who is providing indigent defense in Idaho. For example, before the PDC came in and there's a roster, and we have a roster right now, but there were a myriad of ways to get on that roster. It's not a complete roster. It's part of the litigation with against the state, that we need to know who's providing indigent defense and making sure that they comply. It's not the commission holding their thumb down on any county and saying you must do this, you must do that. What we need, though, is to know who's providing indigent defense in the state of Idaho, and then just to ensure that they're meeting the terms.
Sure.
They're meeting the standards.
Sure. So Kathleen, I want to make one thing clear. I have no problem with the roster. I have no problem with standards. What I have a problem with is the executive director having sole authority to remove people from the roster. So we are working on that section, and but the thing that's important to remember is I'm not just going to go in. First of all, there is a process if someone disagrees with me. That's what the Chapter 3 is all about. So there is a process to appeal. But it's not me just saying without any basis,
this person isn't complying, you have to fire them. That's not what this is about. This is about, let's ensure that people are meeting these standards. It's not me hiring and firing, and it's not me just having the sole authority. They have to meet some very bare bones standards. They have to be a member of the Idaho State Bar. They have
Sure.
to be
And once again, that's not my concern at all. I would like to see more of, the public defender coming forward and saying, hey, I have this situation where this person I don't feel should be on the roster anymore. So I think whether the intent is there or not, to me, the language allows that to happen is for the executive director to have that kind of control. So whether that's your intent or not, I would like to see it worded differently so it's not possible. Does that make sense?
So your concern, and I'm sorry, I missed a few words, but so your concern is that I go to the public defender and say, you have to get rid of this person.
Well, that's to me what the rule says, and that's what I want to not, I'm not sure how to really explain this, but
You're saying it sounds heavy-handed?
it could be heavy-handed. It could be used heavy-handedly. So when anything is written where it can be done, whether it's the intent to be done or not, it can be done. So that's my objection to that part of it. And to have just one person have that authority is another thing that I take exception to. Because we don't know, if you're going to be in the position or somebody else is going to be in the position. I know what you're telling me that your idea is, but the way it's written, I think it leaves it open for a different use.
So let me get right to the heart of that. So one of the things that we're working on, and this isn't me trying to do some power grab at all. A couple of things have come up, though. Our current rules, it's not clear who makes the decision. And I've been on the phone with the Attorney General's office quite a few times saying, rules are silent on this. Who does this? What's this process? Because you need to know that. We need to be transparent so that people know who's making a decision, number one. And number two, how do you appeal that? Who do you go to next? So that's important to us that we have that fair process. But directly to your point, Commissioner, we've heard that. We've heard this statement. And so what we're saying now is generally if the attorney is in compliance, they're on the list. This isn't meant to be, these are the only people you get to do, and this is who you hire, and this is who you fire. We're saying if you meet the standards, if you meet the qualifications, you're on. You're on. And I think that you know this commission well enough. I work for the commission. They come up with policy and our staff carries it out. Our goal is to work with and be collaborative with our public defenders. It is to work with them, but we have to make sure we're meeting the standards. And so that's what the roster's about. So does the language that I just talked about, does that make it a little more palatable for you?
Well, yes, if the language is changed, that,
yes.
If the commission is involved as well, that's a different thing. But to give one person sole authority to remove somebody, I think that's the concern I have. And like I said, intention is one thing, but the language is another thing. If the language can be interpreted to mean that that person can remove them at their discretion, that's where I have a problem with. And I'm all about standards. I'm all about doing their job. And I really think that Kootenai County's done a good job at identifying good performers, and the ones who are not providing zealous defense have been let go. So I want to make that clear that it's a local level thing that really needs to be involved in this as well.
Commissioner, you also brought up about the deficiencies. Our goal was to really be transparent about how the deficiency review process works. And to make it, we have heard comments over, I've heard them now for 22 months about the process. We felt that the current rules were not necessarily authorized under statute. There had been a view that we go in and take over, and that's not what is contemplated, nor is that what's desired by the PDC. And so we wanted to emphasize the first step, which is an informal process that never goes to the PDC. That's where we get to, let's just work this out. This is an easy fix. You know, this is a CLEs aren't met yet. This is a, look, there's this issue. We sit down with the chief defender, we get it worked out. It never even has to go to the commission. And then you work through the process. To the final thing that I don't think any county is going to get to, because counties are working with us, but the final is not that we come in and take over. That's not our desire at all, and that's not what we're set to do. But that we can, if there was just a county that just said, we're not doing this, then there's an issue where we could contract with attorneys to work on that deficiency. So it's not to take over, it's not for us to control your office, nothing like that. But there is a process if a county just doesn't work with us. And
Sure.
it's to bring in, but that is like, that's the last, it's material, it's willful, we're not doing it. But what we've tried to do is make it more succinct. We've worked on language with this. We heard from the clerk saying we're concerned if we get to the level where 14 days to see if we can resolve it. And so some of the language that's been suggested, which I think is fabulous, is to say at 14 days we'll need to resolve, or to set additional meetings to continue this work. And I think that is the spirit of the collaboration that we're looking for.
I'll turn it over to Chairman.
Yeah, okay. And so, Kathleen, this is Chris. I'm just,
Hi.
how are you?
So, Chris,
I'm
you're
fine.
gonna need to get to a
Good to talk to
microphone
you.
for the.
Likewise. Can you hear me?
So,
Yes.
I think
You
she
can
can hear you, but the YouTube needs to hear you. We're good? Okay.
Okay, so on the topic of vertical representation, it appears that the proposed rule might be in conflict with Idaho code. And specifically, Idaho code says, and I'm just going to extract this, it says on a particular case, should to the extent reasonable, practicable, continuously oversee the representation and personally appear, but the proposed rule says shall continually and personally represent that client through the trial proceedings and the preservation of issues of appeal. And I understand that the ideal is to be able to fully vertically represent that client, but it appears that that's not always the case and that's not always possible. Can you comment on that?
Sure. So it's out of Kootenai County that we've heard the most comments about this, that our rules were unclear, that the definitions were a bit contradictory because we have standards. We had a couple of different ways that it was defined. There was a suggestion that we do benchmarks, that you only have to appear at 70% or some period. And I'm not saying that 70% was a number sent out, but you know, what's the number of hearings we have to? That really misses the mark on vertical representation. Vertical representation is that it's one person who's being represented and they're represented throughout. It's not just for the client either. It's also for the cost savings that it represents. It's very inefficient and it's very harmful to the clients when they don't have the same attorneys. We have seen cases where, and this is probably true for every attorney that is on this call today when we've been in court, where we've seen in our careers people who have a different defending attorney in each hearing. And it's a cost for the counties because every attorney has to get up to speed, or it's a cost for the client and/or it's a cost for the client because they don't have a trust. The team concept, which is like a horizontal representation, has been tried. It's been tried in prosecution. It's been tried in defense. And it's good to the extent that there are people who are more familiar with that case, but the person that meets with the client, has the meetings with the client, needs to be in court on substantive hearings.
So,
At the comments, at the public hearing, there was a comment made about people wouldn't be able to get married, people wouldn't be able to go on their honeymoons. That's never the intent. For attorneys, whether you're a public defender or a private attorney, if you have something blocked out, or you have an emergency, you have a sick child, you have a death in the family, those are things that are absolutely unavoidable. Getting cheap tickets to Maui this weekend, completely avoidable. And we're not there to say, you can't ever take a vacation, you can't do those things. That's not it at all. That's not it at all. Because we have been a voice to say attorneys, public defenders are working incredibly hard and they need a break. That's what workload, caseload is all about. But we want to provide excellence for each client in each case. And vertical representation is that you will be with that client throughout. It doesn't mean that you can't get married. It doesn't mean that you can't take a vacation. It doesn't mean that if something happens, there are going to be times that you absolutely have to send someone else in there. We get that. And it's not that infrequent. But the clients need to be aware that their attorney that's going to be who's with them. And, we have met with your trial court administrator and someone that was filling in for the administrative judge and your chief defender, and began that collaborative process. How can we make this work? And that's something that we're committed to continuing with you.
okay, so let me just step in here once. So once again, this is where the intent does not match the language. So the language that is there can absolutely be used different than what you're telling me the intent is. So that's where I take exception, where some of the language needs to be just changed. So it can't be used.
And Commissioner, if you have suggestions, I think sometimes there's this, you need to soften it, but unfortunately when you have standards, you have to be transparent about what the standard is. If, as a public defender, you know that you have something coming up, judges typically will, when they're setting something, you can say, Your Honor, I'm asking you not to set that trial in X period of time. And then you also have motions that you can make. My concern is that I'm interested, I guess, bottom line, in what are your suggestions for the language?
Sure, I will absolutely submit those next week. Absolutely.
Yeah.
Thank you.
And as a further note on my part, I don't have a problem with the language of the code as it currently reads, which really sounds like, make every reasonable effort, whereas the proposed rule sounds more like a command form. You're saying shall. And I can understand that, because I think in the ideal world, that's the way to do it. But I don't see any reason to have to change the language from the current code. And I guess we can submit that in writing.
So I think one of the problems with the existing rule is that reasonably practicable has been defined. It's not defined in our rules, and it's been interpreted many different ways, including if it's not convenient, we're not doing it, or if we can't get our county together, we don't have to do it. And I think it's important that this is a very big cornerstone of improving the defense delivery system. This is what gets the clients through the process. And I'm not saying you can't win a case. I'm not saying without vertical representation, there are lots of different theories about it, but it is, if I go to a private lawyer and hire them, I don't expect, unless they talk to me ahead of time and that there's a reason to be appearing for me, and I have no control over that.
So I'm sorry, go ahead.
No, go ahead.
So from your experience, since assuming your current position here in Idaho, is this a major issue for the state? Or specifically for our county?
Yes.
It is.
It is. It is. And a good thing to do is, you can go on to Odyssey, to iCourt, and just randomly take cases. And you see the representation. And that's what I was referring to, Chair. For those of us who are in the courtroom a lot, it is not difficult to walk in and see vertical issues with cases. When I was in public defense, I saw it. When I was in private defense, I saw it. When I was in federal court, the federal courts don't allow it. You do not, if you are appointed on a case, you do not send someone else. You will be in trouble with the judges. In this district, I can't speak to other districts. You had better make some plans and make the judge aware that someone else will be there and why they will be there. It is instrumental. I saw a case just this last year, and it was just a random one where I think 5 or 6 attorneys were on the case at different times. It is an issue, and it causes, I think it's one of the most harmful things and one of the things that causes defenders to not be trusted, to be called public pretenders. All of those insults that we've all been called and heard, it's part of that, because they don't even know in many cases who their attorneys are going to be. And these are people that, like, I can go get a different civil attorney, or I can go get a different attorney. Indigent folks can't do that. And so when different people are milling through their case, they don't have that trust. And it's also a completely inefficient way to do representation.
Well, thank you. Appreciate it.
So that's kind of all I have for me, and I'll go ahead and submit comments next week. Anne, did you have anything to add today, or do you want to submit comments too?
I would like to add a few comments. Good morning, everybody. I want to start with the vertical representation. I absolutely agree. Vertical representation is critical for clients. Vertical representation where the attorney is assigned to a case and is fully responsible for that case from day one and continues with that case through the end of sentencing, if that's where we get, and filing the appeal, if that's what's necessary.
And I'm so sorry to interrupt, but we're having a real problem hearing you. Could you get a little closer to the microphone just so we can hear your comments? I'm sorry.
How's this?
Why don't you step back, come back here?
Am I-
For some reason, I was being heard.
I was closer than
Or
Filios.
or maybe the podium mic, I don't know.
Maybe we don't know which one's picking it up. How's this?
That's better. I'm glad we're not the only people with microphone problems.
All right.
Thank you.
I will stay right here. I'll start over. I want to talk about how much I agree that vertical representation is critical and important. I think that if you have a public defender assigned to your case, that public defender should ride that case out with the client. That public defender should be the one to get to know the client, assist the client in assessing the charges, develop the defense, and carry out that defense and work with the client all the way through. As you know, Kathleen, we've had a lot of discussions about this. Our challenge here in Kootenai County isn't that our lawyers don't want to appear at every single hearing. It is that our judges hold court at the same time. And so it's just impossible to be everywhere. I think that the rule as it currently is written is a step beyond even the ABA, and I think it's a good rule. I think it has plenty of teeth in it, but it allows for some of the realities of practice in the varying counties. The ABA rule limits to vertical, covering as many hearings as is reasonably practicable. The rule in Idaho goes one step farther and talks about substantive hearings. I think that that is a good rule. I'm very concerned about the rule rewrite. I appreciate the comments today that it doesn't mean I can't approve vacation for defenders, but I'm very concerned that somebody else may not have that same view of it, that may subsequently be in the role of executive director, and things could be treated much differently. While I agree that it's very important to have the same attorney at every possible hearing, I recognize things that are just reality in our world. I know that I've expressed, at least to you, Kathleen, and maybe to others that are a part of this call, our personal practice. And I want to go over that again. And I'm going over that because I think the way vertical is defined right now allows for us to have this discussion and for you to understand what I'm doing and continue to work with our judiciary to try to make things better. But how we do it now is when a case comes in, a lawyer is assigned to the case. If that particular client has other existing cases or gets another case, the same lawyer is going to get that case assigned as well. I view it as very, very important for one client to have the same lawyer to help them deal with all of the problems they might face at a given time. What happens when we start going to court and the realities of scheduling hit, especially now with Zoom when all of the judges are doing everything at the same time, we have calendar meetings. We decide which kinds of hearings are the very most critical for the lawyer to be at. The lawyers will work with judges and clerks to try to juggle appearances, and if it's completely necessary to have a covering attorney step in, the lawyers are to speak with their clients and let them know and have the case prepared for a covering attorney. Certainly not our preference, but that's a reality. And I think the way the current rule is written allows us to live in the real world and allows us to communicate with the Public Defense Commission to try to work to make things better with how scheduling happens. My concern with the rule, the proposed rule as written, is that there are many different ways to interpret it and it could be used as a hammer. I'm not suggesting that this current Public Defense Commission or executive director would do that, but if this rule lives for a long time, we don't know what's going to happen down the road, and I'm just very concerned about that. I'll change topics now. I don't know if there's anybody that wants to say anything about that before I go backwards and start at the beginning.
You're on mute, Kathleen.
Thanks. And if I could say a couple of things. First of all, I thought we had a good first meeting. And part of this is not just directed at, this is a rule that covers everyone that's involved in indigent defense. And so let's say that we have a defender that's trying and a commission that just says that's not the way we want it to be. And again, that's not this commission at all. But a commission, a BOCC that just says, we don't care. It's cheaper to do it this way, or this is what we do. This is what we're going to do. Or you have a judiciary. You have a bench that just says no. This is also directed at that. This is an important cornerstone. And what you're describing, if they are able to make it, but we need to keep working, you know that. I mean, we've had this discussion in our last meeting that all of us were involved in. And I think that it seemed to me that people were willing to talk and to keep moving this along. And that's what we're interested in. But it's not in any way intended to be the hammer. I get the point that we're concerned about if someone else comes in. The reality, though, is the term reasonably practical is not defined, and it has been ignored, essentially. This has been in our standards. And this is one of the bigger fleshed out ones. And there was contradictory language in different places in our rule about vertical. What we've tried to do is really just make it clear what is vertical so that you can use this in your discussions with the judges. This is what's required. And the commission is in its 5th year. I meet with people who were on the Legislative Interim Committee, the influence here has always been, we want to provide resources, we've got to get these standards up, because we're found to have not been providing constitutional representation. That's huge. But we are here to support, but there's also got to be clarity in what does this mean. And reasonably practical has been defined a lot of different ways. And I think that as we look at this, again, this commission, and as it evolves, the mission has always been to support, to try and get to the standards, to work through it, and I don't see that changing. I am, having said that, very interested in language. We have been given language by different folks. I'm very interested in it. Our whole team is working through it. So please feel free to help us with that. But you and I know that we've had discussions about what is reasonably practicable and practical. And we need to be able to define the terms and to make sure that everyone's on the same page, because whether you're in Custer County or Kootenai County, you deserve excellent representation.
I would agree that indigent defendants certainly deserve excellent representation. And I did appreciate the conversation with our stand-in administrative judge, and I hope that those kinds of conversations continue. I do want to say, though, that whenever we've talked about vertical and whenever we've talked about what does reasonably practicable mean, I've said the same thing. I haven't asked for a percentage of hearings. I don't know who suggested that. I've said the same thing. It's always been my goal to have the same lawyer handle the same client's entire set of problems that we're faced with, whether it be one felony case or a felony and a child protective and a misdemeanor case. It's always been my goal to have strong communication with the client and take their input. I think that's reasonably practicable. My definition hasn't changed, and I would love to propose language and examples that maybe can be incorporated. That would take me kind of to one of the overarching themes and concerns I have about the whole new proposed rules. And when I made public comment, I said it, and I want to say it again. I think the Public Defense Commission has done some excellent things to help indigent defendants across the state of Idaho. And I've enjoyed a lot of the negotiated rulemaking meetings and other meetings we've had. I've learned a lot about the practice of law, about indigent defense, and about the running of my office. I am really disappointed that we have not had this rule rewrite, which is really what it is, go through the regular negotiated rulemaking process. I've participated in negotiated rulemaking in the past. I participated last fall when we started talking about the two new rules, the resource equity and the independence rules. I enjoyed that conversation. I participated this past July in the Zoom call. I was disappointed it wasn't widely attended, but I enjoyed the conversation we had there too. That was my first clue during that July meeting that we were going to have a rule rewrite for the existing rules. I did appreciate having a copy of the proposed rules sent my way to be alerted that there was something in writing to review. My request would be that we put on hold this rule rewrite and go through the negotiated process. I think there's a lot of good things in these rules, but there are a lot of areas that I have some significant concerns. And I'd like to have the opportunity to hear more, to learn more, and to be a part of a really solid rule rewrite. I can go through some of the concerns that I had. I did that in the public hearing, and I'll do that in writing. But I'm asking you as the executive director and the commission to slow down and let us have the regular negotiated meetings where hopefully we can come together and work as a team to rewrite these rules so that we all understand what they mean and so that the commission has the benefit of the input from the chief public defenders, from contract attorneys, from county commissioners, and so the rest of us have the benefit of understanding in meetings where we can have an exchange of ideas, the purpose of the rules and what's really trying to be accomplished. I think that's how we're better is when we work together. So that's my overall request.
Thank you, Ann.
Yes, my comments I made in the public hearing, and I'll make them in writing as well, and I'll get those out to you, Kathleen, and to the commission on Monday afternoon.
Thank you.
Does Bill have any?
Thank you.
Bill, this is for Commissioner Bill Brooks. Bill, do you have any comments?
I can understand the concept of vertical representation, but to the extent that it puts a tremendous potential burden on the county, I want to look at that some more. It's not simple. I am opposed to any of these men. You will do this and you will do that, without regard to the budgetary impact. So my feeling honestly is that it's a little too quick and we need more dialogue from both sides.
Thank you, Commissioner. It's good to hear from you again. It's been a while. A couple of things. Please, this is what the comments are about. The comment period. Please, we want your input. We want any suggestions you have. We have really tried to be transparent this year. We were absolutely committed to sending out the outline in July, sending out the working draft in August, sending out the publication as soon as it occurred. And I think maybe it was September we sent out the working draft. And then and making sure that people have been involved and have access and can talk to us and work collaboratively with us. You know, agency rules, Idaho has a unique approach because of this negotiated rulemaking, and I think I applaud the commission for choosing to do the negotiated rulemaking. One thing that I do want to emphasize is, and I started the meeting with this, we have truly tried to be true to, we have tried to be true to the prior negotiated meetings. And as we've learned things, as we've heard from commissioners, as we've heard from defenders, we're trying to implement those things. In no way are we trying to circumvent any process. We want people to be involved, and we are under deadlines, just as you are. And we really want your input. We have made changes to what was published already to take to the commission. We're keeping our leadership informed what we're doing, and we will be talking about the comments at the meeting next week. The meeting next week is not a public testimony. It's for the commission to do its work. I sat through the meeting when the workload was determined, and I had not yet started, and it was a fascinating thing. I too have been part of the meetings and heard criticisms and heard comments, and we've tried to take those into account and make sure that everyone is a part of this. We can't always agree on everything, but we want you to be aware that we are listening and we are making changes according to comments.
Well, I appreciate that, but I think if the group that puts this together would look at it a little more from a commissioner's standpoint, and from three people who are working with a lot of demands on a budget of the county, it might come out a little different. That's all. It's very easy to say you should do this because it's the right thing to do and it's the best representation. I understand that. In the ideal world, that's all we would worry about, but we have to attach dollar amounts to those things, and commissioners all over the state have to work this into their budget.
Commissioner Brooks, you bring up, it is not a unique perspective at all. We are hearing that. We hear it all the time. We heard it before this process. A couple of things about that. One of the concerns that's been voiced is the cost of the equitable resources. we have looked at this long and hard. Two things about equitable resourcing. We have counties that are concerned with this, but if you recall last year, we sent back all 44 applications and asked the court or asked the commissions to please start to line item investigators, witness costs, expert witness costs, paralegals, social workers, other costs that they saw. And all 44 counties have started to do that. That was a process to get us to equitable resourcing of defense. And I don't see that this is going to be a dramatic cost. But part of our mission is to advocate with the legislature what is needed for indigent defense. So let's say that CUNY gets to this point and we continue to have discussions like, what is this costing you? What are you seeing with this? We're a year ahead in budgeting, of the counties. So we, today, in fact, is the conclusion of any kind of change you want to make to your budget. Today's the deadline for 2022. My goal is to always be reporting to the legislature on behalf of the PDC and making recommendations and telling them this is what it's costing the counties and this is what we need to be funding. And so the more that we can have these discussions and you tell me these are the actual costs we're seeing, Kathleen, and it's kind of one of those things, which comes first, the standard or do we estimate the budget? Do we guess about it? But thus far it's worked pretty well. I think, the workload is a classic example of being able to say to the legislature, this is what we think it's going to cost, and being able to cover that. And then as we're giving them more data about this is what we're seeing, these are the inflationary costs we're seeing for formula, these are the inflationary costs we're seeing for workload. But my goal is that we work with all 44 VOCCs and clerks to be able to inform the legislature. This is what they're going to need. This is the trend we're seeing. And they have then data that they can rely on and that they can move forward with us. I see us as being we're certainly not the lobbyists for you guys, but we are in this in partnership. And so the more you can talk to us about those budgetary concerns, about that data, that's what we're really, really looking for. In addition to improving defense and going in partnership with you.
I'd like Kathleen to make a couple comments. I think it's important have this dialogue between county commissioners and the commission. One of the things that I think is very, very important is that we have to take a look at this from the standpoint of all 44 counties. And I understand the conflicts and the problems that you have with budgets. When we start looking at things, sometimes I often refer to the difference between Clark County and Ada County. Very, very much difference in terms of population, in terms of what they have as far as resources, et cetera, in terms of going through the process. I know a year or two ago when the Association of Counties was trying to raise the levy rate, excuse me, on the Justice Fund, that raised some real concerns for me because you are under a 3% cap, and so all you're basically doing is taking money from someplace else to put it in the Justice Fund. And the Commission looks at these things. We are truly looking at how we can best serve the indigent clients out there with the indigent defense. The other issue that we have to keep in mind is the lawsuit that the ACLU has with us, and we're trying to balance that lawsuit with what we can do to provide proper indigent defense.
Thank you.
Fair enough. So is that it then? Any more comments?
Turn your mic on. Turn your mic on. There you go.
Any more comments? This is Chairman Chris Filios.
Yep.
If not, do we have any public comment? I guess not. Thank you, everyone. Thank you, Director.
And we'll send
Kathleen Elliott. Thank you, everyone else. Commissioners, members of the Public Defense Commission. And on that note, the time is now 10:06, and this meeting is adjourned. Have a great weekend, everyone.
Thank you.